has assessed your punishment at 10 years in the prison. You'll receive credit for any time served. And there's to be a fine of $5,500.
Does that time served include the ankle monitor?
No, it does not include the ankle monitor. It includes any time that you've actually been in custody. Chapter 62 registration. Is there anything else with regards to sentencing from either side, state, defense?
No, Your Honor.
All right, Mr. Lemon, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
I didn't really read over it.
All right, would you like a chance to read over it? All right. All right, Mr. Lemon, have you had a chance to review the Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Do you understand it?
Yes.
All right. So because this was a jury trial, you do have a right to an appeal. If you are unable to afford an appellate attorney, your attorney knows to file the proper motions and the proper documents as far as notice of appeal, and then an attorney will be appointed to represent you on appeal. Do you understand?
Yes.
All right. Do you have any questions about anything
I do.
with regards to the sentence?
Oh,
If you have questions about the legal implications or the reason the jury decided what they
no,
decided.
nothing like that. I mean,
Mr. Gonzalez?
Yeah.
Yes?
I think it's for her. Like, I have a bunch of bills and stuff that are coming out of credit cards and stuff like that. Is there any way I can get to that, or
As far as, do you mean calling someone or something to take care of that?
We'll talk to him about how he can handle that, Judge.
All right. All right. So you, as I stated before, you do have a right to an appeal because this was a jury trial. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand? And with regard, we're off the record, with regards to any bills that are coming out of an account that you may have, I don't know, that may be something that you can handle by phone, but I don't know how the phone call will work at the jail, because I know at the jail,
yeah,
those phone calls
I kinda
cost.
use computers, but
Yes. So you may want to, your attorney said they'll speak to you about that.
Right.
All right, is there anything else? All right, what is the status on that? Because May 25th, I was told there was a sealed case.
Yes, Judge. So it is still awaiting indictment as far as I can tell. I just pulled it up right now.
All right, do you know when that's going to be done? Is it family violence or criminal trial division?
It's a family violence case, Judge. I can reach out to, I know who the family violence intake attorney is. I can
Okay,
try and see if they can make a video of what's going on.
all right, do we know what the charge is?
Assault by prosecution.
All right. Ms. Ferguson? On this, who's the intake person for family violence?
So our, the 187 would be Victoria Fernandez. I don't know if she's gonna handle this specific case.
Okay.
I know they've changed how the intake for TTD works now, and I
Okay.
don't know if that still applies for family violence.
All right, so this is the last reset for this. After that, this is either going to trial or it's not. Do you understand?
yes, ma'am.
All right, Ms. Ferguson, can you give me a 30-day reset in July? No, July. Okay. All right, Ms. Ferguson, we'll give you a reset form, then you excuse.
Thank you, Your Honor.
You're welcome. Tom McCaslett.
We're ready to announce it.
All right, thank you. All right, where are we on this case?
So, Judge, in addition to the cases that are in your docket today, he's got 3 unindicted cases.
Mhm.
I I think we're heading towards a resolution, Judge.
Okay.
But we just need to review those copper cases.
All right,
get
and
an
what
offer. If the court would consider recalling us in a week or two,
Okay,
we might be able to get an offer and get something done at that point.
all right. Ms. Ferguson. Do we have any room on the docket for the week of July 3rd? Is that enough time for you all?
Judge, that's not a, well, this is not a docket that thing.
No. I mean, just the week of July 3rd. So it'll be the 5th or the 6th. If not, we can do the week after. All right. Are you okay for the 10th?
Yes, Judge.
All right. So we'll be back on July 10th.
Thank you, Your Honor.
You're welcome. Thank you. All right. Are you all ready to proceed?
No, Your Honor, we're asking for continuance
Why?
on MTR.
No, why are you asking for continuance?
There is a new number one. I need to go, it's unindicted, so I need to go over the details with my client, discuss the plea bargain offer being presented by the state.
All right, Ms. Ferguson, recall Mr. Carrillo for 10 days.
Right. Yeah.
All right, and Norma, he needs to have a reset form.
Oh, yeah.
All right, is there anything else? Then, court is calling 2018 CR 10107, State of Texas versus Priscilla Amaya. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Lorraine
Defense.
Eastern for Ms. Amaya.
And are you Ms. Amaya?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, I did.
Are you the same Priscilla Amaya who was placed on deferred adjudication in 2018 CR 10107 for the offense of possession of a controlled substance, penalty group 1 less than 1 gram on June 28, 2019 for a period of 3 years? Is that you?
Yes, Your Honor.
State?
Yes, Your Honor. Violated condition number 5 in Bear County, Texas. The defendant Priscilla Maya did then and there failed to report to the supervision officer as directed for the months of November, December 2021 in violation of condition number 5.
How do you plead to that? True or not true?
Sure. We'll waive the remaining violating conditions, Your Honor.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, Your Honor.
Court will find violation of condition number 5 true. Is there an agreement?
Yes, there is, Your Honor.
Yes.
Yes, for adjudicate guilt, revoke the provision, and sentence the individual to 11 months in the state jail facility.
No objection, Judge. That's our agreement.
All right, Ms. Amaya, are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, so what went wrong with you?
To be honest with you, Your Honor, well, I relapsed and I didn't want to report. I thought working was good enough, but I didn't have my family intact, my kids all together. They were disappointed in me, so they stopped talking to me. But
Sorry, can you speak up?
now I have my kids back in my life and I have my first grandbaby, so I see things different. I know I do need help. And I'm willing to take that help as an outpatient when I get out of Bear County Jail.
Here's the thing. If you want to remain on deferred adjudication, I will let you remain on deferred adjudication. But you're going into inpatient treatment or either you're going to felony drug court. Now, you say, oh, I want to do my time, I will get out and I will take care of things and I will be clean and sober. 9 times out of 10, that's not going to happen. You know why? Because you are looking at 2 years in the state jail facility and you couldn't do it. And you are a person who should not be around your grandchildren or your children because you don't have control of your addictions. You're using opiates. You need help. So if you want, here are your two choices. State and defense, they came up with their agreement. Here's your choice. One, you can be referred to felony drug court. If felony drug court accepts you, great. If they don't, you go into inpatient treatment. Or you can go to the state jail facility for 18 months. Either way, your life, the time is going to pass. Either it's going to pass with you bettering yourself by taking care of your drug addictions, or either it's going to pass with you marking days off the calendar, just doing your time at the state jail facility. So which do you prefer? 18 months?
Talk to those on behalf of Mr. Miles, Your Honor.
And are you Mr. Miles?
Yes, ma'am.
All right, Mr. Miles, did you have sufficient time to speak to your attorney?
Yes, I did, ma'am.
All right, counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Miles, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We waive, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Miles, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1 gram to 4 grams? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, I did, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Miles, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 4 years in the prison. The state is silent on your application. They're taking in consideration NIMAG number 712181. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Judge, yes, but just with one addition, and speaking with defense counsel, one term that wasn't added. Because my understanding is that they're still going to ask for a bond to be set while sentencing is pending. Is that if the defendant does not appear for sentencing at the designated date, that he is open to the full range of punishment.
All right. Did you understand that?
Yes, I did.
Does anyone want to write that in?
I will,
I
Judge.
think
Sure.
in writing.
Thank you. So you understand if you do not appear at your sentencing, then you'll be subject to the full range of punishment?
Yes, ma'am.
And you understand that the full range of punishment is up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Did you review the paragraph with your attorney entitled waiver of appeal paragraph, and did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor, have there been any such motions?
Motion's filed, none ruled on, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Okay.
State any evidence?
State offer states to the one in all attachments.
Without objection, Your Honor.
Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Sorry, Your Honor.
No problem. Thank you. And what is the case that's being taken into consideration?
It's another drug, offense, Your Honor.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. On this case, state, will you be able to present to the court a different date for his criminal history and NCIC and TCIC?
What do you mean, Judge?
Oh, his history.
Oh, just to run it again?
Yes.
Yes, Judge, we can.
All right, then what we'll do, because I want to know that will help me make a determination on whether or not to grant his application or not, because otherwise, if we don't do it that way, his reset date is going to be far off. So when do you all think you'll have that?
It shouldn't take that long. It'd be done in minutes. Really.
Oh, in minutes?
Yeah, as long as we tell our investigator and he has the time to do it.
Well, all right, so if we come back the week of July 5th, would you all be able to have it, or do you need more time?
We would be able to have, Judge.
Your Honor, I apologize. I'm scheduled as number 1 for a jury trial in Maverick County. I'm the only trial.
Okay, and which date is that for you?
It's gonna be July 5th. I'm not sure if July 7th is, it shouldn't be more than 2 days.
But you all are in. How about if we put it on maybe July, Norma, can we do July 10th that week? All right, is everybody okay with the week of July 10th?
Yes, Your Honor.
Same, Judge.
All right, what date? All right, so we're going to come back on July 10th,
Yes, Your Honor.
and I'll base my decision off any evidence that's presented to me. So if there are some witnesses you want, let your attorney know, and I'll listen to those as well.
Okay, ma'am.
So your choice is, do you all want the PSI? Because if you want the PSI, it's going to be far off, or either I can make my decision based upon the criminal history. It will be the criminal history and witnesses. And honestly, the pre-sentence investigation report, they interview you, which if your attorney wants to call you as a witness, I can hear, and they tell me what your criminal history is. That's basically what it does. And then they give me a recitation of the narrative from the police report, which you all have already stipulated to. So as far as your upbringing, where you went to school, who your family is, how you feel about this case, that's something, if your attorney wants me to know about, you can tell me on July 10th.
We'd probably waive PSI, Your Honor.
All right, so you want to waive the PSI?
Yeah.
Okay. Yes. All right, so if you can give a reset form, we'll see you back on July 10th, and at that time, I'll make my decision, okay?
Okay, thank you, Judge.
All right, you're welcome. Yes, do you still want to make the bond, or you just want to wait till July 10th?
Would like to have the bond considered.
All right,
Thank you, Judge.
you're welcome. All right, are you all ready on Priscilla Amaya?
Yes. I believe so.
And then after this, Priscilla Amaya.
Your Honor, I
Yes.
was able to report on this one to
Mhm.
see if she could be reconsidered. She was in the program previously.
Mhm.
So we're just trying to get that information together, and if they said that they could probably confidently say that she would not be reconsidered.
Oh, I had
So
an
we
idea
were
they
just
wouldn't.
in the middle.
Oh, if you want to have time to do that? Okay.
Ready whenever.
Deborah Burke, who do you have? Hello,
Good afternoon.
good afternoon. Yes, who do you have?
Adam Sancho.
Could I see the file on Adam Sancho?
Adam.
So on Adam Sancho, I know he has a new case, Ms. Burke, but what is the new case and where are we on the discovery for her getting that?
So he has several new cases, Judge. At least one of the cases that's awaiting indictment is a drug case. I don't think we have labs back on that.
Okay,
The other cases should have been indicted already. I think one of
It's
them,
a theft of a vehicle.
theft of a vehicle, unauthorized use, and then a evading.
all right. So I'll give you all a reset date in 1 month. Is that enough time for everybody or do you need longer than that?
I think that should be enough,
That's
Judge.
Okay.
All right,
The reason why there's some hesitancy there, judges, I
the
think
lab.
there may have been a resolution that we may have come to possibly.
Well, what I'll do is I'll give you all a 1 month reset. And if you want to come sooner,
Mhm.
you can come in sooner.
Thank you.
All right, thank you. Ms. Ferguson, on Adam Sancho, can I have a 1 month reset?
The courtroom shifts. The jury is seated. Guilt is already decided. Judge Stephanie Boyd calmly announces the punishment phase. No emotion. No commentary. Just one question left. How many years will this decision take from his life?
On Adam Sancho, can I have a 1 month reset? All right, so July 27th. And Norma, if you'll give him a reset form.
Thank you.
You're welcome. Thank you for coming back.
Okay, I'm sitting.
These are done. Are we ready on Amaya or you're still discussing?
We're ready, Your Honor.
All right. So we're back on the record. In 2018 CR 10107, State of Texas versus Priscilla Amaya. So, Ms. Amaya, have you had a chance to discuss things with your attorney?
Yes, Your Honor.
So which do you prefer?
Your Honor, we're going to take the state jail time, but we are requesting that the court, if the court has the ability to refer or recommend her to a therapeutic community there for drug treatment, we are requesting that.
All right, then the court.
I think that will allow her to get some credit for her time at state jail.
All right, is she waiving her right to appeal then or no?
Yes, Your Honor.
All right, then the court will find you guilty. The court will grant the motion, sentence you to 18 months in the state jail facility, give you credit for any time served, and the court will recommend the therapeutic community. Therapeutic community will not increase the amount of time that you're in custody, but I do not have the authority to have them place you in there. The only thing I can do is request and recommend it, but you're also going to have to ask for it. You understand?
Yes, sir.
All right, I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement,
Well, not
Well,
actually.
she's waived her right to appeal.
Okay, that's right.
Yes.
You're right.
Thank you. And you've waived your right to appeal. You do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. How old are you?
I'm 40.
All right, you're 40. You still have a lot of your life in front of you. and you need to make a decision. And I know staying clean and sober is hard. And this is from somebody who's never done drugs, but I understand it's hard based upon my experience in different treatment courts and based upon the fact that I'm having a struggle giving up ice cream. And ice cream is not even as addicting as the drugs that you're taking. But if you don't stop, one or two things are going to happen. Either you're going to continue going in and out of the prison, or either you may end up with a bad batch and you may end up overdosing. And I don't think you want your children or your grandchildren to read about you in the news where it's bodies found on whatever street it is. And then they finally identify it and it's you. You understand? But you're going to have to work for it. And when you get out, there are plenty of places that have free treatment for you. Okay.
Yes, ma'am.
All right. Good luck to you.
Thank you.
You're welcome.
Thank you, Judge.
Thank you. All right. Thank you. Are you already on Wardell Lemon?
Yes, we are.
I'm going to give you a chance to switch over. Do you need to switch over anything to start?
No.
Okay. All right. All right. I'm sorry. Yes, we're going to bring the jurors in. Yes. Sorry. I forgot about that. They say they have witnesses.
That happens, I'll give press present. We have like about 10 messages in a row.
Bye. And Norma, I'll talk to you about the other cases that are still on the docket. Okay. All right, thanks.
If you just the mics.
No problem.
Excuse me.
Thanks, Judge.
Oh, thank you. Bye, guys. Bye-bye. Yes. Oh, thank you. Yes, I'm gonna enjoy it. Well, so we will not have court that week, so you all can enjoy time with your family too. And then I don't think it makes any sense for, well, of course it makes sense because that's what the calendar says, that July 4th is on a Tuesday, but it makes no sense for everybody to come in on a Monday and then you're off on the Tuesday, then come back on a Wednesday. So our next date will be July 5th. I know it's his birth. Mom knows it's his birthday. Mom is. Oh, you beat me to the punch. Okay. Happy birthday, Mom. All right. Thank you. Thank you. Yes.
The day you gave me, July 27th, I'm in San Patricio County that day. I'm 3 other days that week.
All right. Norma, if you could change that date for me, please.
Of July?
They in the hallway?
Good afternoon, Madison. I wanted to start out by asking you a few questions. Now, you're aware that Wardell has been found guilty of the child, right?
Yes,
And although the events have ended, are you still affected by what Wardell did to you?
yes, the trauma that he's caused, it's never gonna go away. It's always gonna be there and it's always going to affect me.
Specifically, how has this affected your relationship with your mother?
My mom simply didn't choose me. She chose her boyfriend over her own daughter, who she birthed out of her. didn't choose to believe me. And it hurts that somebody who's supposed to raise you, somebody who's supposed to love you and teach you how to love other people wasn't there. And it still affects me to this day. I mean, that's why I didn't want to say anything for the longest time, because I didn't want to lose the relationship I had with her. But after seeing what side she chose, it made me realize she doesn't care about me. That's just simply the truth.
Has she attempted to contact you at all since you spoke out about these actions?
She has never tried to say happy birthday or I miss you or I love you. And the only thing she's ever tried, I guess you could say, by reaching out is sending a message of me with her saying I love you. And after that, she's never said anything. And that was maybe 2-3 years ago. And she's unblocked on iMessage. She could message me at any time.
How has this affected other relationships you have with your dad and Linda?
It put trust issues towards men in my life in general. I don't trust them because of what happened, but that's just the trauma that he caused on me. And I don't trust men. I just simply don't.
Has this affected the way that you see men or even boys your age in general?
Yes.
How has it done that?
I don't desire that type of relationship or affection from a man because of what happened, because it scares me. And I don't know what a boy capable of my age will do to me because I have that fear of what he did to me.
Do the thoughts about what Wardell did to you still come up?
And as much as I try not to think about it or push it further back to where I don't remember things, it will always come up and it will always be there.
Now, before all of this happened, how did you see, or what was your relationship like with Wardell before he did this to you?
I'm not going to sit here and say for when I was little, I didn't see him as a father figure. I did, but that's because he made sure I did see him as that. He made sure I had trust with him so that I allowed him to do what he did. And he made sure we had common interests in what we did so that he could do what he did. He knew what he was doing and he did it in a smart way.
And how does it make you feel now at this stage in your life, knowing that that trust was taken advantage of?
It hurts because as a child who's somebody who you looked up to and trusted, it hurts.
And do you have any plans to attend any type of therapy or counseling?
Yes.
And when are you going to be doing that?
As soon as this is over, we already have an appointment.
State passes the witness, Your Honor.
Okay.
Proceed, Your Honor.
Yes.
Good afternoon, Madison. Real quick, you mentioned a little bit ago about the fact that your mom is unblocked on Instagram or some social media.
I said she's unblocked on iMessage, yes.
Why did you mention that?
Because she claims that she tried to reach out to me multiple times and that she's blocked on everything. She's only blocked on Instagram.
So let me ask you this, where did you hear that?
She said it
When?
when she was testifying.
Were you in here when she was testifying?
No,
So then who did you hear from?
we watched
You watched what?
and didn't she say, Shauna say on her testify that She was watching it too?
Did you watch Shauna's testimony?
No, I just watched my mother's.
So you watched your mother's testimony?
When it was done, yeah,
On what?
on YouTube.
I'm sorry?
On YouTube.
Your Honor, can we approach?
Yes, just a second. Ladies and gentlemen, I'm gonna have you step outside of the courtroom. And so I will call you back in.
This is the moment everything stops. The defense asks for a mistrial. The judge doesn't hesitate. No argument, no sympathy, just 4 words. The motion is denied. Cold, final, and absolute authority.
But with regards to her testimony, is it sufficient for the defense that the jury be given an instruction that they are to disregard any testimony from this witness related to her mother's attempt to contact her?
Yes, Your Honor.
All right. Is there anything else from either side?
No, Your Honor.
We can bring them in. All right, everyone, please be seated. Ladies and gentlemen of the jury, the rule has been invoked in this courtroom. I know you all have heard me tell jurors each time that, tell witnesses each time that they step from the witness stand, that the rule has been invoked. What that means is you can only discuss your testimony or have discussions with attorneys for the state or the defense. In this case, it appears that this witness viewed testimony that was not allowed for her to view. So with that being said, this is what I'm going to tell you you are to disregard. Any statements made by this witness who's on the witness stand related to whether her mother had contact with her or not, or how her mother had contact with her, you are to wholly disregard. So it is as though that question was never asked. It is as though that statement was never said. Does everyone understand?
Yes, ma'am.
So you're not to consider it whatsoever if you are able to reach punishment in this case. Does everyone understand? All right, any questions about the court's instruction? All right, thank you. Defense?
Yes, Your Honor. Madison, you were asked a question about counseling, which you were going to start, I guess, after this is done.
Yes.
And you have not had any counseling in the last 2 or 3 years?
No.
Have they told you that one of the consequences of this conviction is that Wardell will have to register as a sex offender for life?
Yes.
Nothing further, Your Honor.
All right, any other further questions?
Nothing from a state, Your Honor.
All right, thank you. You may step down. All right, state, call your next witness.
State has no further witnesses. The state was.
All right, defense, do you have any witnesses?
Your Honor, the defense will call Nolan Anderson.
And Your Honor, preliminarily, the state would object to any of the defense's witnesses who were present during Madison Keeley's testimony and would ask that they be excluded from testifying in this case.
All right, was this person present?
This person was present, Your Honor. The rule had not officially been invoked by the court regarding this. In addition, Your Honor, anything that they are going to testify to is only related to Mr. Anderson, not for her testimony.
All right, that will be overruled. All right, you have a seat here, sir. Thank you. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand and have a seat.
No problem. Anderson, please.
Just
how do
one
you
second.
know-
I'm sorry,
Oh,
just
no
one
problem.
second. No problem. No doubt that the defendant committed such other offense or act of misconduct, if any. In the event you have a reasonable doubt as to whether any other such offense or act of misconduct was committed, or as to whether the defendant was involved in such other offense or act of misconduct, then you will wholly disregard the evidence, if any, which may relate to any such matter. You are instructed that the defendant may testify in his own behalf if he chooses to do so. But if he elects not to do so, that fact cannot be taken by you as a circumstance against him, nor prejudice him in any way. The defendant has elected not to testify in this punishment phase of trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you, in determining the penalty to be assessed, to fix the same by lot, chance, any system of averages, or any other method than by full, fair, and free exercise of the opinion of the individual jurors under the evidence submitted before you. The length of time for which the defendant is in prison may be reduced by the award of parole. Under the law applicable in this case, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot be accurately predicted how the parole law might be applied to this defendant, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. A suitable form is attached hereto for your verdict, if you should care to use the same. However, such form is not intended to influence you in any way in arriving at your verdict. In any event, the verdict must be unanimous in writing and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, and forms are attached. State, are you prepared to proceed?
The statement reserved there.
All right, defense.
May it please the court. Counsel. Ladies and gentlemen, as I told you during opening of the punishment phase, we do respect your verdict. We understand you come to this verdict based upon the consideration of the evidence. What we're asking you to do now is consider Wardell Lemon, the person he has been to his family, to his friends. We're asking you to consider taking away a man who has provided so much and has been not a perfect man, but has been responsible, taking care of those around him, help those to become upstanding men, help those friends that he had continue with their lives and deal with issues around them, help those who have their own children deal with whatever issues that come before them. You're going to read through this and you've probably heard, and you're like, well, there's a issue of parole. It tells you what the parole law is, but that's not really for you to consider. There is a parole law. Whether or not he gets out at a certain time is not for you to determine. It'll be for another entity to make a decision. What we also want you to consider is that you heard from the testimony, he's going to be labeled and have to register as a sex offender for the rest of his life. So at some point when he does get out, he's going to have to register. So that means he is going to have to be confined, even though he is not in prison anymore. That is a lifetime registration. That is something that he's going to have to deal with and live with based upon your verdict, and he understands that. So whatever you decide as far as the punishment, he's still being punished long after that occurs. We understand that this is a serious offense. And we understand the circumstances surrounding. it. But a couple things I also want you to think about is the fact that this family is still trying to drive more nails into that coffin. Going through and trying to provide more evidence as to rebuttal as to what was testified during guilt minutes. Try to make it clear that my mom never reached out to me. She's unblocked. All these little things try to manipulate your feelings as to how you should view Wardell Lemon and Amanda Lewis. All those things that show you who they are. So we understand you've come to the verdict that you have come to. We're respectfully asking you to come to a decision to sentence Wardell to 2 years in the institutional division of criminal justice. And if not 2 years, then the lower end of the punishment range. Thank you, ladies and gentlemen.
All right, state.
Ladies and gentlemen, as you've heard, the defendant is facing 2 to 20 years in the prison because of this charge. And if you've paid attention, you've seen him shed tears while at that table today. State will submit to you that he's not crying there because of what he did, because of what he caused to Madison. He's crying there because he's now facing the consequences of his actions almost 10 years later. Now, Madison got up on the stand and told you she thought of him as a father up until this incident happened. And the defendant took advantage of Madison at that young age and broke the trust that she had in the man that she saw as a father. He groomed her. You heard testimony yesterday about that. He took advantage of her little by little, making her comfortable with what he was doing to her because she didn't know at that time that it was wrong. He knew it was wrong. And he took it step by step by step to try and protect himself in making sure he never got caught and end up in this situation today. The defense wants you to take him into account in this punishment phase. But what about the victim? The defendant caused all of this damage. Sure, he's going to be a sex offender, and rightfully so. He's charged with indecent contact to a child. So yes, he will be a sex offender because of his own actions, not by anything that Madison caused. She is the victim. She's the complainant in this case. She has nothing to do with what is now going to happen to the defendant. You've heard a little bit of information about how he's now a 2-time felon. He was given a chance previously in a case where he injured his own child. And that was revoked because he couldn't abide by the rules set by the court, and he was sentenced to 6 months. So he's already shown that any punishment is not enough for him, because if he's given a chance, he will take advantage of it just the way that he took advantage of Madison. You also heard from Shauna again, who yesterday, if you'll remember, testified that sure, she would trust Wardell with her kids. And even now, as he sits here, a convicted felon of a sexual charge against a child, she's telling you to your face that she would still trust him. I don't know what that says about the defendant. I don't know what that says about her, but you can take that into account. You heard from his son, and they made it seem as though the defendant is this big, important figure in his life and shaping him into who he is today. Caleb was raised by his great aunt and his great uncle. He testified to you that he doesn't suffer any problems from not having seen Wardell for the first 10+ years of his life. So it's the defense who's trying to manipulate your emotions into taking that background information into the back with you. It's up to y'all in the jury to send a message that this type of crime is not taken lightly in our community. So when you go into the back, again, think about Madison. Think about how this is going to affect her. Something that was not caused by her, but by the defendant's actions, and how that's going to affect her for the rest of her life. Think about how every time she thinks about this action, she's going to think about the relationship with the mom that she never wanted to lose, but was forced to let go of because of the defendant's actions, because she chose this defendant over her own daughter. Now, the complainant, Madison, has had this hanging over her head for the last 10 years. And found the braveness inside her to finally come out one day and tell her story about what happened. And like you said, like counsel said to you previously.
After hours of testimony, the jury returns. The verdict is read: 10 years in prison, a $5,500 fine, lifetime registration. The judge looks at him and speaks plainly. This is no longer debate. This is punishment.
Has assessed your punishment at 10 years in the prison. You'll receive credit for any time served. And there's to be a fine of $5,500.
Does that time served include the ankle monitor?
No, it does not include the ankle monitor. It includes any time that you've actually been in custody. And there's to be Chapter 62 registration. Is there anything else with regards to sentencing from either side, state, defense?
No, Your Honor.
All right, Mr. Lemon, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
I didn't really read over it.
All right, would you like a chance to read over it? All right. All right, Mr. Lemon, have you had a chance to review the trial court certification of defendant's rights to appeal with your attorney?
Yes, ma'am.
Do you understand it?
Yes.
All right. So because this was a jury trial, you do have a right to an appeal. If you are unable to afford an appellate attorney, your attorney knows to file the proper motions and the proper documents as far as notice of appeal, and then an attorney will be appointed to represent you on appeal. Do you understand?
Yes.
All right. Do you have any questions about anything
I do.
with regards to the sentence? If,
Oh,
if you have questions about the legal implications or the reason the jury decided what they
no,
decided,
nothing like that. I mean,
Mr. Gonzalez?
Yeah.
Yes?
I think it's for her. Like, I have a bunch of bills and stuff that are coming out of credit cards and stuff like that. Is there any way I can get to that, or
As far as, do you mean calling someone or something to take care of that?
We'll talk to him about how he can handle that, Judge.
All right. All right. So you, as I stated before, you do have a right to an appeal because this was a jury trial. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand? And with regard, we're off the record, with regards to any bills that are coming out of an account that you may have, I don't know, that may be something that you can handle by phone, but I don't know how the phone call will work at the jail, because I know at the jail, those phone calls
I kinda need
cost.
computers, but
Yes. So you may want to, your attorney said they'll speak to you about that.
Right.
All right. Is there anything else? All right. Thank you.
can I talk to?
Yeah, you just